SJC-12696, Commonwealth v. Carlos Vieira.
Good morning, may it please the court. Catherine
Wait,
Semmel.
one second. Be careful, WBUR could be photographing you too. We have a face made for radio on the court, so we're well positioned. All right, now Miss Semmel, you may proceed.
Good morning. Catherine Semmel on behalf of the Commonwealth, and with me at council table is ADA Kim Fatella, who is a trial attorney in this case. We are here today on the single justice's reservation and report on the question whether assault and battery, indecent assault and battery on a child under the age of 14 qualifies as a predicate offense under the physical force clause of Section 58A. And it's the Commonwealth's position that that clause of Section 58A, which defines predicate offenses, requires essentially a felony involving a battery or attempted threat of battery consistent with the common law definition of force. As a analogy, in my brief, I've discussed a little bit about the case law that has taken place in the last few years about the Armed Career Criminal Act. There is a guiding United States Supreme Court case, which is actually, I think, very helpful in this case, both as a starting point and a juxtaposition to the phrasing involved in 58A. The Armed Career Criminal Act includes a similar clause, which requires an offense with an element of physical force. Over the past several years, the courts have defined what that meant in a way that the court hasn't done with 58A yet, but which I think informs your analysis.
What about our interpretations of the Armed Career Criminal Act? Do we have anything useful in our case law?
Yes, we do. And basically, in an appeals court case, Cologne, and subsequent cases, including SJC cases, the court has really adopted the analysis in Johnson. And I refer the court back to Johnson only because I think it starts a little bit earlier, and that the courts have adopted almost whole scale the analysis, but without actually recreating exactly the steps that the U.S. Supreme Court went through in Johnson in a way that I think is helpful, because the court there did start with the common law definition of what physical force is and really discussed it at length, and used essentially the definition of a battery, which is an offense touching without justification or excuse, but then moved away from it for reasons that were specific to that context and which don't follow in the context here. Specifically, in the armed career criminal context, the court found it important that they were essentially, that the physical force clause was defining a violent crime. And they read the violent into the physical force as they felt that they should do. What's different in the 58A context is that we're not defining a dangerous offense. We're establishing predicate offenses that can then lead to a question of dangerousness and an analysis by the court.
How about that immigration case, the United States Supreme immigration case, I think Stimia, which has language very similar to 58A. Have you looked at that at all?
I have, but I'm trying to remember. That's not the misdemeanor domestic violence case.
I believe it is. It's the one that has very similar language to our 58A and raised concerns comparable to the residual clause concerns.
Well, my recollection of that case, if I'm thinking of the right one, is that the court in that case dialed back the definition of a physical force that was adopted for the specific reasons of the Armed Career Criminal Act in Johnson and then in our cases, and relied on the common law definition, which they felt fit with that circumstance. Whereas in Johnson and in our cases adopting Johnson, the courts have felt like a higher level of force is required because of the violent crime aspect of it. And,
So can you win if we were correct in Barnes?
well, yes and no. I think in Barnes, we came before the court, and I was involved in those two cases that were before the court last fall, and we asked the court to find that penetration of a child is the equivalent of force. And what we didn't ask the court to maybe first consider was what exactly is the definition of physical force for purposes of 58A. And the court rejected the argument that the Commonwealth had proposed, and also, I think, didn't really answer that threshold question, which about what physical force entails in a general way. And I think actually that the Barnes decision may have confused trial courts in trying to apply 58A in its wake, because I think it might suggest that it is limited to a facial element of force in a description of an offense. So I don't think was the court's intent. I definitely don't think was the legislator's intent in passing that statute, that it had a broader implication. And really, of course, the physical force clause of 58A has become much more important in many cases because this court, in fact, struck down the residual clause consistent with the federal case law.
But isn't that the point? The legislature didn't have to contemplate this physical force issue on rape or aggravated rape where there's a differential in age, or an indecent assault and battery where the touching might be offensive, because the assumption would be that it would have fallen within the residual clause. So they never would have grinded down to this issue.
That's possible. That's certainly possible, Your Honor. And it's even more applicable in cases, in offenses that really center around an assaultive act. The residual clause is even more important there, but certainly it is important here. And I think it's important to remember that the clause, in fact, requires first that there be a felony, and then that it involve physical force, which the Commonwealth suggests is essentially battery.
I don't understand what you mean by that. First, there'd be a felony, and then, so first you're saying when you do the analysis, you check off felony, and then you check off whether it's physical force in the felony? Is that what you mean?
Yes, exactly. That the statute requires a felony offense that has as an element of the offense the use, attempted use, or threatened use of physical force. So it does have to be a felony first. So the idea that it should be a felony that involves a battery on a person is a reasonable interpretation of what the legislature would have set up in terms of a predicate, of a threshold inquiry for determining whether we can have a dangerousness.
But don't you have a logical problem? I mean, what you're saying is, under Barnes, if an adult has sexual intercourse with a child, that is not a predicate offense, correct? Under Barnes?
Under the Barnes decision, yes, Your Honor.
Unless you were to charge it to be a forcible rape as opposed to a statutory rape.
Correct, that's what the court held.
So if the same individual, as is alleged here, both touches, does not have penetration, or has penetration plus some touching, which would constitute indecent assault and battery, then that means it is a predicate offense. So that the lesser included sexual offense is a predicate offense, but the more serious sexual offense is not. So how do we get past the logic of that?
And I think that is why I'm asking the court to take a step back and to go back beyond, kind of before our argument in Barnes, and consider broadly what physical force means. And that might, in fact, if this court, in fact, defines physical force, which I ask you to do as a matter of policy to provide guidance to the lower courts as to how to implement this section, it's possible, certainly if the court adopts the Commonwealth's argument, it may give it reason to reconsider the determination in Barnes that rape of a child doesn't qualify.
Is it possible that indecent assault and battery is not a lesser included of that particular rape charge in Barnes?
It is possible, Your Honor. I mean, certainly, it's a factual determination. The court has said several times that indecent A and B is a lesser included offense of statutory rape, but has done so with a little wiggle room, like acknowledging that they don't exactly match up because of the age differential, the age that doesn't match up, and indeed the fact that if you look at indecent assault and battery, it requires a touching essentially without legal justification or excuse that may be implicit in a rape of a child, but it's not specifically in there.
Wouldn't the age distinction just be for children that are 15 that cause it not to be?
Yes, Your Honor.
A lesser
I think that's exactly true, and I think so. What the court has said that for a child that's under 14, and indisputably, and that's an element that isn't usually disputed, that it qualifies. But that is a little bit askew from the normal, from the typical lesser included analysis, which looks strictly at the elements, and it is a little bit askew. And of course, the court in Barnes also, I think, took note of the fact that there was an offense of rape of a child, both with and without force, which the court noted provided some further indication to the court that
But it wasn't at the core of the reasoning.
it was not.
So, I mean, there, I guess what is peculiar is that, is there any way to distinguish for a person under 14 a rape that, I mean, an indecent touching that would otherwise be consensual, but for age, which is one, as opposed to one which is forcible and against that person's will?
I'm sorry.
If you have, in rape, you have statutory rape and you have forcible rape.
Yes.
You can distinguish between the act of a 17-year-old and a 14-year-old engaging in sex versus a 17-year-old forcing himself upon the 14-year-old.
Correct.
And there are two separate crimes. If that same 17-year-old does an indecent touching of a 13-year-old, is there anything that would allow us to distinguish between one which is done with the consent apart from age of the 13-year-old versus a 17-year-old forcing himself upon the 13-year-old?
I don't believe so. No, they both fall under the statute.
Didn't we defined physical force in Eberhardt in a different context, though, right?
Yes, and the Eberhardt is part of the armed career criminal context. And in the armed career criminal context, the court, following the Johnson case, has defined it as a violent or substantial force capable of causing injury or pain. For a number of reasons, which I discussed a bit in my brief, the higher level of physical force required in that context is not required here. For a couple of different reasons. As I said, in the armed career criminal circumstance, once you have a violent crime, it mandates sentence enhancement. Here, once we have a predicate offense, it requires the start of a dangerousness proceeding. It qualifies us to file for a petition for a dangerousness proceeding. So you can imagine why a higher degree of showing might be warranted.
But the bottom line is, rape of a child is so abhorrent. Indecent assault and battery on a child under 14 is so abhorrent that you don't need to have force for it to be an egregious criminal act. By definition, it shouldn't have to require force. It's so horrible.
I completely agree,
So
Your
then what
Honor.
do we do with that? I mean, the assumption was that this would be within the residual clause. It isn't, and the solution, it seems, might be with a different branch.
There is certainly legislation pending, which, when I checked on Friday, is still in the very early stages. It was proposed by the governor in January, I believe, which was after Barnes came out, in which in that bill, there are offenses enumerated, such as this offense, such as rape of a child, are enumerated in that bill. So certainly, it's possible that there will be a legislative solution, but we are all aware, of course, that there's no certainty. There's no certainty in that, and I would respectfully disagree that rape and indecent assault and battery are things that we would just think would go in the residual clause. That I think that when you have a felony offense that has an element of physical touching, of assault and battery in it, that falls clearly within the physical force clause and is ample evidence to trigger.
We can only get there if we reverse Barnes, right?
I think that,
Or
I think
could
that
we
it would be
clarify it?
or perhaps clarify it.
Well,
Yes.
how would you clarify?
I think I think that it requires a look at what exactly physical force is. And I think that when we presented the case, we may have bypassed that question because we thought that it was dealt with by the fact that the penetration equals the force, which was essentially our saying that it is a touching. But we didn't ask this court to really look at and consider what is physical force and how are we going to define it so that it can be used by the lower courts and used by us here today. I think that certainly if the court followed the Commonwealth's definition of physical force, that the Barnes decision would be incongruous, to say the least, and that it would be appropriate for the court to revisit it in light of those new findings and consider whether or not it might wish to reconsider the decision in Barnes.
Isn't there a difference, though, between the definition of force and the definition of offensive touching? You're equating them.
I'm equating force with an assault and battery, which includes three branches of possible crimes: a harmful touching, a reckless touching, or an offensive touching. And I do think in this context that the broad definition of that offense is appropriate for determining what physical force is. That is really the quintessential force at our common law. And both statute and case law tell us that unless there's some indication otherwise, we presume that the legislature meant the common law meaning of the term.
So is Justice Bud's question yes? The answer to it is yes? It is an offensive touching?
It includes an offensive touching.
Yes, okay.
Yes, that would be my theory.
Okay, thank you.
Thank you very much.
Mr. Nasons.
Good morning. May it please the court.
I may need to lift your voice a little bit.
I can do that.
Especially for a Monday morning.
You may have to tell me to lower it a little bit.
Okay, we'll see how it goes.
Good morning. My name is Attorney Gil Nason. I represent Carlos Vieira in this matter. And I would argue to the justice here that indecent A and B is not a predicate offense covered by the 58A. If you look at the statutory construction and of the statute 58A itself, the main part of the statute and the reason that it was created was to make sure that we removed people that were dangerous people. The main purpose of it originally was based on domestic violence, around domestic violence. And even as this court at some point said that the whole point of the dangerous status was a measure intended to protect the public from violent acts of a dangerous individual. What we're looking at in the elements of indecent A and B, in the elements of indecent A and B does not include force. It does not include a physical force. It is an offensive force. It is a force that is essentially against consent. It is a statutory.
So what other cases are there that would make that distinction between force and an offensive touching, like assault and battery that's a bit offensive, but it's not involving force?
Well,
if we took the sex part out of it.
Correct. So if you look at, right, an
those
assault and
crimes.
battery, and the ACC looked at the assault and battery, and where they determined that, the three types of touching, and one of those are offensive touching, and I believe this court looked at the offensive touching and said, hold on, for armed career criminal, offensive touching does not qualify. And that's why they look into what actually happened during the offense, instead of just looking at seeing if it said assault and battery on it. So if it's offensive touching, and the bigger problem is if this court determines and overrules Barnes and says that indecent A and B under 14 is a predicate offense, what essentially this court would be saying, that if a parent walks in on a 2 13-year-olds, touching the other 13-year-old, and they decided to say, wait a minute, this kid touched my daughter, my son, that child would now be subject to a dangerousness hearing.
Have we backed into this because of the way courts have been interpreting the bail statute?
I believe so. I believe so. And I believe the problem with the 58A statute, at least from my experience in the trenches, essentially every time a 58A is started, the courts always find somebody dangerous. Now, most of the time there are conditions, but it's almost a foregone conclusion when a 58A is asked for and granted that the court will find the person dangerous, and there'll be some conditions. Sometimes the conditions are almost no conditions. However, they'll say the person's dangerous, here are the conditions. In the past 5 years, I think I remember a single case where a court did not say somebody was dangerous. And that's the problem with the statute actually in itself. I mean, the statute was meant to make sure that we keep people that are going to commit new crimes, essentially the same type of crimes, to protect people with domestic violence, to protect somebody that goes out and rapes somebody.
What about protecting people from someone who preys on underage people for sex?
So I would agree with you. I think that would be a perfect example. However, in that case,
Isn't that this example?
it is not.
Well, I mean, how old is this child? He's 13 years old?
It's 13 years old.
And how old is your client?
My client is 48.
And say there were 10, if we had 10 of these, I understand we only have one of these, but what if we had 10 of these? That we had 10 times where he's getting together with 13-year-old kids off of Grindr. Would that change things? Would that make him potentially dangerous? Because he'd be dangerous, but just not necessarily in the way we're describing it in this statute, right?
So I would agree with you. I would agree that he would be dangerous if this was 10. However, I mean, as this court has said, we don't look at the facts of each case. We look at the elements, and maybe we should look at the facts of the case, because the facts of the case, even if you look at the facts of the case in this case, would make a.
I think you should ask the other members of the defense bar whether we should do that or not.
Yeah, from a defense perspective,
You may wanna walk that one
I
back.
would agree with you.
Yeah.
Because that would just open it up to a lot more of these,
Right.
and that's definitely a part of a frightening thing to see.
I mean, at some level, this case is easier than Barnes because it involves an indecent touching as opposed to a statutory rape. But at some level, it's more difficult than Barnes because in Barnes, we could say, listen, if the Commonwealth has any indication it was forcible, then charge forcible rape. But what do we have, if you're right, and if we have a situation in which a 45-year-old, or for that matter, a 25-year-old, is against the will of the 13-year-old, not engaging in any sex that would be viewed as consensual but for age, but literally, forcing the kid's pants down and doing a touching that is forcible and against the will apart from age. Right now, if you're right, that's still an indecent touching, and there would still not be a way to have that person be held for dangerousness.
So that was my main concern as we were looking through this brief and looking through the brief and determining how this even squares with my own mind, where you're absolutely right. I mean, if you pull somebody into a bathroom or somebody's in a bathroom, somebody, reaches in and grabs somebody, there's no question that person, there may be a time where that person should be at least afforded a dangerous hearing based on the Commonwealth. However, this court said it's an element of a charge, and maybe it's for the legislator to also look at and say, hold on, maybe we need different stages, as we have different stages of rape as they stand right now. We do have an aggravated form right now of indecent A and B, aggravated being a mandated reporter or aggravated with also, there's other crimes involved with it. Now, those in themselves, I believe that once you go into an aggravated indecent A and B, may change that.
Could you do what we're doing in the immigration context and look into the factual underpinnings and move beyond the elements to do what Chief Justice Gantz just talked about, which is to draw distinctions in A and B, indecent A and B, between forcible indecent A and B and non-forcible, at least for these purposes?
I think that would be something for the legislature to do. I do. I believe that there should be because there is kind of this, as you said, kind of this catch-all, where there is a rape with force and a rape without force. So we're here with the same, in essentially the same position, without a law to catch that. And it's easy enough for the legislator to do that, and it appears that the legislator is looking at this right now and saying, okay, this is what we're looking at doing.
We're doing that in the immigration context without legislation, right? So it doesn't necessarily require legislation to do that.
However, if you look at it, and I'm not sure I necessarily agree with you.
Your client may still win, but when we have somebody who's grabbing someone and pulling their pants down and touching their rear and do it repeatedly, we might have a vehicle for a 58A for them, right?
Correct. Correct.
And what would that vehicle be? Because this focus is only on the elements.
That's a tough question.
That's why I asked. But, is there, do the elements differ in the sense that the Commonwealth for a child under 14 can rely upon the fact that it is without consent as a matter of law?
Correct.
Would it matter if the Commonwealth alleged it was without consent as a matter of law as well as a matter of fact, which is the example that I'm giving, distinguishing as you say, the pulling a kid into a bathroom against his will and doing a touching versus having both people agree to go into a room and to engage in consensual touching?
So I would agree that if, depending on the type of touching, as a matter of law compared to against consent, not statutory consent, that there could be some way this court could craft something that would say that depending on if it's a consent issue as a legislative consent, saying that the legislator has made a rule saying that 14 is the age. However, if the consent is against the will of the victim, then I believe this court could craft something to that effect. I'm not sure, though, if you look at the way the statute's written and the way the law is written, if it would give, based on the rule of lenity, if it would actually let people know what's going on.
So we'd have to craft a new crime? Yeah, I'm
Or
sorry,
for the
do I not
legislator
understand?
to craft a new crime, or at least to,
But we couldn't.
no, you cannot.
Okay, so there's nothing akin to the forcible rape / statutory rape parallel as in Barnes?
I do not believe so. But I know this court has, at least in an opinion, writing to the legislator has some effect usually on the legislator to get things done.
Don't count on that.
I mean, and if you look at other states, they have different degrees. Unfortunately, Massachusetts does not. And just
Well,
the
when you say
problem.
different degrees, do you mean like a model penal code type of degrees?
Correct.
Is that something you think would be useful?
I do. And I'd also say that would also should apply to standard assault and battery. There should be different degrees of assault and battery. Then maybe we wouldn't be in this situation as we stand today. That an assault and battery, if you think about an assault and battery, you can walk up and touch somebody on the shoulder that they didn't want it. That's considered an assault and battery. You could also walk up and hit that person in the face and actually be essentially the same assault and battery. And there's no true comparison to those two. But the punishment is the same.
Okay, anything else?
I think I covered it all.
Okay, we will do our best. Thank you.
Thank you.